Okay, good afternoon. Thanks everybody for joining today. Welcome. This is the Interstate Compact State Council meeting today, September 15th, 2021. And just on the agenda, quickly, we noted, I think the last meeting, that we'd have a September meeting just to cover some of the Interstate Compact national rule proposals that we're going through, but looking at what we had to promote for October's agenda, we went ahead and decided to combine all those into one quick meeting today. So this will alleviate the October meeting and move us on to December once we get done. So thank you for being here. Thank you for taking the time. The first item on our agenda is to review and approve the minutes from the June meeting. And because we're going remotely, we will have on any sort of substantive decision-making, which I would include on this, I'll have Jenny Bauer do a roll call vote to make sure that we're in full compliance with the new version of the open door law that went into effect this year. So subject to all that, if everybody's had a chance to review the minutes, if there's any changes, I'd love to hear those. If not, I would entertain a motion to approve them, and then we'll have Jenny go through the process.
I'll move to approve them.
Oh,
This is Laura.
I'll second.
Okay.
Please.
All right, I had Laura in the motion, and then Bernice is the second. So Jenny, if you'd like to call the roll, please.
Thing. Justin Forkner.
Sorry, maybe it's my connection, but who did you
Are
just
you a
call
yes?
on me?
I'm sorry.
Did you just call on me?
Yes.
Okay, perfect. All right, you cut out right at the key moment. Then we're doing good, folks. We're off to a strong start today. Yes, for me.
Mary Kay Hudson.
Yes.
Bernice Corley.
Yes.
JT Parker as proxy for Chris Naylor.
Yes.
Laura Berry.
Yes.
Judge Humphrey.
Aye.
Joel Gruber as proxy for Rob Carter.
Aye.
And Don Travis as proxy for Terry Stigdon.
Yes.
And Jenny, we just had Steve Luce join as well. I'm not sure if he has had an opportunity to review the minutes.
We'll give him a chance to join.
Hi, Steve. Yeah, as you come on, that's all we're at that point now of reviewing the minutes from the last meeting. We've had the motion in a second, gone through the votes. If you have had a chance to review it, otherwise, whatever your vote would be.
Steve, you're muted.
I am fine. I reviewed them this morning.
Okay, thank you.
All
Great,
right.
Justin, unanimous.
Thanks. So the minutes from the last meeting are approved. We'll move on to the consolidated adult and juvenile compact update. And April, I'll go ahead and just turn the whole thing over to you at this point. But if you wouldn't mind, as you go from topic to topic, just take a pause so we can take any questions on those.
Okay. So we presented at Popeye earlier this month with adult and juvenile compact. Angie was present for that as well. We discussed what needed to be done in order for our counties to remain in compliance. And we did a general rules update and an overview of everything for that. We had great turnout. We had a lot of questions, and I feel like the audience was really engaged with that. And then also for compliance with an adult, ICAO's launched a new feature for the app, and it's called junk reporters. So basically, this is helping us clean up compliance on an internal level as well. It shows us which counties are creating cases and they're not doing anything with the cases, or they're creating cases that need to be merged with other offenders because they have duplicate profiles in there. So that's helping us clean up internally as well. And then also on the juvenile side, the Business Analysis Committee, Indiana holds a position on this committee, which is NITA. And they're currently vetting unity enhancement requests to present at the Technology Committee for consideration. And these enhancements are going to help continue the process of streamlining everything and make it more user-friendly and a user experience, which will decrease the amount of time to process cases. Does anybody have any questions about those two updates?
April, go ahead.
Okay, so we're gonna go with the, at this point, Adult is having a virtual business meeting and it starts September 27th through the 29th. April should have sent out a link for the members to see if they would like to attend the meeting. And then also for 2022, we're gonna be back in person for that. And that'll be September 26th to the 29th, and we'll be in New York City for Adult. And for Juvenile, we'll also be virtual this year as well. And that'll be October 4th through the 7th. And also a link should have been sent out to members for that if they wish to attend. If so, we'll be back in person for Juvenile, and we'll be in Burlington, Vermont, and that'll be October 5th through the 8th. And that's all I have for Adult and Juvenile for the annual business meetings.
Just out of curiosity, and I don't want to open the door one way or the other, Mary Kay, do we cover that for members since we're the Interstate Compact Staff Agency? Or is that the individuals?
Justin, we have not, to my knowledge, ever had a council member outside of our staff attend the ABM. But if there was interest, I think we would definitely do whatever we could to support that.
Okay. Yeah, well, that's fun. Watch this. If you want to go, let us know. We'll help you get there. So there we go. There's our decision on that. Thank you very much. If you are interested, I have been to some of those and they are informative for me as someone. This is not my first area of practice or anything I have deep experience in, but I went to the adult and juvenile sessions a couple of years ago, and they are good training opportunities for folks like me to sort of see how folks like April actually apply this with their colleagues around the country. So if you're interested, reach out to April, Mary Kay, or myself, and we'll help on that. Next then is sort of sorry, April, did you have anything else on those? Okay. Next then is really the meat of why we're here today, the 2021 proposed rule amendments. Mary Kay, are you going to take the lead on this? And then what is the outcome you're looking for? Obviously feedback and input from the council members, Mary Kay, but are we going to need a formal motion to approve what's there in order for you to go and vote on this?
Justin, yes, that is correct. So at the annual business meetings that April just reported on, both for the adult and juvenile, this is a rulemaking year. So the proposals that we're going to be discussing today are the final version of the proposed amendments to the adult and juvenile rules. They've been through public comment. They've been through the rules committee. Everyone has reviewed the public comments made on those drafts. And so these are what's going to go up for vote. So every state's commissioner is going to be asked to vote in favor of these rules individually at the annual business meeting. So for the purposes of today, we'd like to review these with you. And at the end of our discussion, I think between me and Jenny, our recommendation is that we review all of the juvenile and then vote on them as a package. Hopefully that will be agreeable to the group, but certainly if there are any rules that are of a concern that you wish for me to vote differently, then we can have a separate discussion on those, but it would be easiest to vote on them as a package just because of the volume. And then also the same on the adult side, review those and then vote on them as a package.
Okay.
And then I will take this council's direction on when I vote on them at the ABM.
Okay, why don't you go ahead and get started with the juvenile, and then when we get to the motion part, we'll just have Jenny do a roll call vote again on each of those.
Perfect. And so for these, I will say at the outset, I think April's going to display these on the screen. On the juvenile side, there are 15 different rule proposals, which is a fair number. I would say most of them are really for clarification purposes or to incorporate the fact that we are working with Unity as our new case management system for the juvenile side of things. I would not say that there's anything in here that I personally consider to be of concern. And our staff has reviewed these rules and they've watched the entire process as these proposals have been developed. And April, correct me if I'm wrong, but our team here with the Office of Court Services in support of these rule changes. Is that correct?
That's correct.
Okay, so we'll walk through these and to the extent there's any questions, please let us know. And then April and Jenny can help me with any of the content if I'm missing anything. And just as a reminder, this group was sent links to these proposed rule amendments when they were posted for public comment. So I'm happy to report on our first rule proposal under definitions for the definition of absconder. Justin Faulkner provided some comment to the Rules Committee, of which I'm a member of the Juvenile Compact Rules Committee, surrounding the proposed language that you're seeing today. There was originally a proposal on the floor for consideration. Justin commented on that. And what you see is a result of his comments in which the Rules Committee decided to remove any implication or to remove the portion of the definition that required there to be a proof of intent. And so Justin's comments were well received by the Rules Committee, and that's the new language that you see before you.
Mary
Justin,
Kay,
would you
mind
like
if
to
I just-
comment on that?
Yeah, first of all, Justin's comments were well received by the Rules Committee has never been said before, I think, probably in the history of the Rules Committees I'm engaged with. I had two thoughts actually, and one of them is the one that they acted on. If the idea was to remove the concept of intent, they had left in the phrase "to avoid legal process or authorized counsel," and I thought that didn't actually do what leaving those two words in still conveyed a measure of intent to me. I had a more substantive concern that probably flowed more from my lack of understanding or application of these rules about whether or not this should be an intentless sort of status. Based on the initial postings for the comment was because it was often lack of proof of intent. To me, initially, that didn't seem like a reason to do away with the intent requirement and make it basically an intentless status if it carried some sort of punitive measure that came with it. But they did take the first one. The second one I just brought up, and if they didn't take it, then they didn't take it. But those were the two comments I had.
April, Jenny, any comments on that?
Nope, I did see that Don Travis has his hand up.
Oh, Don?
This has nothing to do with the rule, but I would ask that the text be expanded just a little bit. It's kind of hard to read. So if we could do that, that'd be great. If there's any way to zoom in a little, that would be great. Thank you.
Okay, so then we'll go on to the next definition, which was a proposal by the Rules Committee, was to amend the definition of court. The first probably issue with the definition is the definition included the word in the definition, which they realized, so they decided that it would be good to remove that. But also this is for the purpose of expanding or more operationalizing what we mean by the term court when we're looking at who is authorized to sign forms under the ICJ rules. Sometimes court was being very narrowly defined as a judicial officer, as an elected judge versus a commissioner or a magistrate. And so they decided to expand that definition as to anyone who's been given authority and has jurisdiction over juveniles under the compact. The next definition is it was a brand new definition for proof of entitlement, which is essentially documentation that substantiates someone's authority to request the return of an individual, of a juvenile. April, I don't know if you have any comments about this, about anything that you all were seeing in the field that you think from our perspective necessitated this new definition. Any examples you can think of from Indiana that caused a problem with this?
I don't think we had any issues that caused a problem with this whatsoever.
The next proposed amendment is to actually Rule 2103, which is the rulemaking process itself. If you look under 1A, there was kind of a procedural problem with this rule in the sense that the way it was written actually allowed for rules to be proposed or amendments to be taken essentially on the floor during the annual business meeting, which is a practice that has not been in place for a number of years, really because it's very complicated. And any proposed rules or amendments that are not presented and reviewed prior to the annual business meeting, they're not properly vetted. And this process that we're going through right now is an example of commissioners are typically directed on how to vote by their councils. And so anything that was actually introduced and entertained during the annual business meeting was not able to go through that process. So they're making that change. And then the change in number 2 is just in support of that, that the rules committees actually will review proposed rule amendments. Generally speaking, the rules committee only drafts proposed rule amendments if it's originating from the rules committee. So this just indicates that they would review those drafts that are provided by anyone else. The next section is proposed by the Technology Committee. It's Rule 3101. This is, until April gets there. This proposed rule amendment really is a reflection of the fact that we have adopted a brand new system, electronic system for managing all of the communication and notifications through the juvenile compact. It's really not a substantive change, just kind of updating the language that we're using. Rule 4102 is on the sending and receiving of referrals. When a referral packet, which is a request for supervision, transfer of supervision on the juvenile side, this rule change incorporates the addition of a photo in the referral packet. And then it also clarifies that Form 5, which is notification from the sending state to the receiving state, should be forwarded to the receiving state either prior to or at the same time the juvenile relocates to the receiving state. Just gives more specificity to the time frame.
Mary Kay, Bernice has her hand raised.
Yes, Bernice.
So this is just for clarification, and I'm sure it makes sense to people who do this work every day. But as I recall, the photograph requirement, which makes sense, 2 things. I thought the rationale was to comply with real ID. And so thinking about a juvenile, does there need to be more detail on the type of photograph that is being sought? Is my first question. And then my second question is, just from reading it, and again, I'm sure it makes sense to people who do this work, I kept wanting to say photograph of the juvenile. Obviously, we're talking about the juvenile, but I just wondered if there should be a little clause after it to make clear that we're talking about a photograph of the juvenile. And like I said, are there standards on the type of photo that is needed?
Are you able to respond to Bernice's questions?
There hasn't been a standard for what the photo requires, but I do know that also this also helps with Unity, because now we have a feature in Unity where we can upload the use ID. As before, our old system JIDs, we didn't know. So it's also to help with the real ID, but also so that we can have identification for the sending state or the receiving state when they're going out to meet that child, because they haven't met that child for the first time.
So April, are we assuming that this photo is like an institutional photograph? Like if this child has been under supervision or something, like when would a child have an ID, other than to be able to provide to the other state?
It's just the sending state taking a picture. They can be on their cell phone or anything of the child, and they'll upload it into the system. So that can work for this photo.
Any other questions on that under 4102? Under 4103, which is a transfer of supervision procedures for juvenile sex offenders, there is some clarification under section 2 stating that the information provided by the sending state, it put a clarification in there that if this information is available, which indicates that in some cases the information may not be available. They've also added the photograph component to this as they did in the previous rule. And then also a new language on the Form 5 notification, which was also reflected in the previous rule. It's the same language, the proposed amended language in the previous rule under Form 5, that the Form 5 shall be forwarded prior to or at the time of the juvenile relocating. Okay. On Rule 4104, under the authority to accept and deny supervision under Section 6, if the transfer of supervision is denied, and this adds language to take into consideration that the juvenile may already be in the receiving state. The sending state shall within 5 days, and the new language is to secure alternative living arrangements and submit an updated referral or return the juvenile to the sending state. So the justification for this is that there could be an investigation in which the receiving state does not recommend certain living arrangements, but there's not necessarily an automatic reason to send that child back. There could be other living arrangements that could be acceptable. And so looking at the sending state to secure the alternative living arrangements and submit an updated referral. So essentially it would be a new investigation. April, is that correct?
Yes, that's correct, without making the child go back and start over.
Right, so we don't want to move a child unnecessarily. We just in a timely fashion need to be able to kind of move on, basically move on to Plan B if the first set of living arrangements does not work out. Under Rule 5101, which is supervision, services, and requirements. In Section 4, this clarifies that the receiving state is required to provide an update to the sending state, not only in cases where there's been a change in residence, but also in cases if there's a change with whom the juvenile resides. So if you have new individuals that are entering the household, that information needs to be sent to the sending state. And then the new language under number 5 permits the sending state to request additional information. And then they can also essentially propose an alternative living arrangement, or they can order the return of the child if they don't find that acceptable. Under Rule 5102, under the absconder report, or the absconder provision, under number 2, there's a reference to a Form 9 absconder report, which is really kind of a change in procedure under Unity and the way Unity logs the different types of reports. So rather than generically being referred as a violation report, it's more specific, and that is a report on absconders. Under Rule 5103, reporting juvenile noncompliance, failed supervision, and retaking. This rule states that on request from, there's several different categories there's actually 3 different categories. When the sending state shall return the juvenile in accordance with these rules, and there was apparently a gap under Section 4C, where you could have a juvenile student, but the rules did not take into consideration a juvenile who resides independently in a receiving state. And so April, in that context, you could have a juvenile for the purposes of the rules, but who is living on their own, correct? And so that could be, is that ever anyone under the age of 18, or is it always 18 and over?
It's usually 18 or over.
Okay. So this was just to add those individuals to this group. Under Rule 5103, I'm reporting non-compliance, failed supervision, and retaking. Section 1E actually expands on what we mean by efforts or interventions to take into consideration that states should be incorporating the principles of behavior modification into their attempts to get kids into compliance or to get the juveniles in compliance by the use of therapeutic interventions, incentives, and sanctions. And those would be adopted or implemented in a manner that's consistent with policies and procedures in the receiving state. And then I think that takes us to 7104. Yeah. So section 7104 actually distinguishes or clarifies the distinction between juvenile jurisdiction and adult jurisdiction when we're talking about retaking procedures and extradition. And then Rule 7105 also adds under section 1 that a juvenile's charged as an adult is subject to the, or this includes a juvenile who's charged as an adult and is subject to the extradition under the Uniform Criminal Extradition Act. And I have to admit, this is not an area that I'm familiar with. So April, if you have anything to add to that about what this looks like or what challenges we've had and the purpose of this change, please share if you have any experience with that.
I haven't had any issues with it or any experience with it, but I do know that it's basically when it takes into effect when a juvenile is here and the sending state decides the age of majority, the juvenile can already be an actual adult. So if they get arrested for a new offense, how will we return that child? And so this is just clearing up that language from that part.
Rule 8101 is on travel permits. And this changes the language to say that juveniles who are relocating, the travel permit needs to be issued prior to the acceptance of supervision. Or they're required, rather, including if they're already in the receiving state. And then under number 3C, if a child is issued a travel permit prior to the acceptance of supervision, meaning a referral has been made to a sending state, but they haven't investigated it and they have not yet made a determination, the sending state must or shall send the referral within 15 business days. This is for the purpose of expediting that process so that a child is not in a receiving state longer than needed before the referral is sent and the investigation begins. And then there's actually an exclusionary provision for parolees and juvenile sex offenders. April, how will that be different for kids on parole and the juvenile sex offenders? Is that because they're not permitted to travel at all prior to the determination?
Typically, the parolee juveniles are in, they're still in whatever facility that they're in until the request has been approved.
Gotcha. So they're not in a position. Okay. And I think that's it for the juvenile.
So do you think I guess I'll open the floor for a second. If someone has specific comments or input on any of the particular rules that we need to take it separately, Judge Humphrey.
Two things. First of all, could we look at the definition of court briefly? It's one of our first one. I think it was the second one we looked at.
Yes, sir. April, are you able to bring that back up? Thank you.
The only question I have on this rule is we say with constitutional and statutory authority. Do we have courts out there that are created for a specific purpose by statutory authority that with that limitation that should this be an and or an and? I'm not trying to be overly
Yeah,
specific.
that's a really good point. I mean, like for instance, in case of a superior court, which is statutory authority versus constitutional. That's a really good point.
So as I'm saying, we're trying to clear up so we avoid issues with what's a court. And that's something that popped out at me. So I don't know if it makes sense or not, but I want to raise the issue.
No, it definitely makes sense. I think probably for the purposes of determining whether or not the council would want to vote on this rule. Obviously that got missed during the discussion, and whether or not Judge Humphrey, you think this is, for lack of a better way to say it, more problematic than the original rule itself. Because I think the challenge we were having with the original rule was people were not comfortable signing it because they didn't think that they had the authority to sign it. I mean, I'm not a court, I'm not a judge. Using the term court, people were associating that with an elected official versus a referee or a commissioner or a magistrate.
So I'm not understanding the full process here. This will go through at the next step. Could we potentially approve this improvement in the language with the suggestion that we make that further amendment to clear this up even further?
At this point, Judge, they don't accept amendments from the floor, which is actually one of the rules that they're tidying up this time around, because it doesn't give people the opportunity to take it back to their council or otherwise fully vet it. So at this point, this group would decide to either vote in favor of or direct me to vote no on this particular rule, kind of separate it out. So, I mean, I think, your point was well taken, that if this is an and, this is severely limiting for anything in Indiana other than a circuit court.
So we might be making a bigger problem than we already have.
Correct, yes.
Okay, before we keep going on that, because I think Judge Humphrey, that's a great point. Are there other rules that there are particular comments on? Because if not, what I think I'd do is.
Justin, before you leave that, I just had a comment as I look at that. And I think that Mary Kay kind of hit it. It's both the statutory courts and the courts that are created by statute, or those offices that are created by statute. I don't read it as a constitutional and statutory authority. I read it as separately. Just my comment.
And I guess I could probably go both ways. If I looked at it, me personally as a lawyer, I'd think I needed both constitutional and statutory authority, and I think that's what Judge Humphreys is looking at. But that would be the discussion for us: does this cause more confusion than the original version would have for Indiana? And before we kind of get to that, if there's other rules that there are issues with, I'd love to hear that. If not, I would what I'd start with, or what I'd suggest, is we vote on all those others that don't have issues, and then we can discuss this 1-101 in a little more detail and determine what direction we want to give Mary Kay. Judge Humphrey?
I have one other question, and that is on the amendment regarding juveniles treated as adults. And the reason that I'm asking that question is because of the new statutory language we have here in Indiana effective July 1st. And I think the federal statute effective, I think it's December 21st, maybe, defining juvenile arrestee. Are we satisfied with the language that we have here that will properly encompass those new legal authorities that we're going to be addressing? Any child who's a direct file, as we know, or a waiver is going to be required to be held in a juvenile detention facility unless we make certain findings every 30 days. And that's the only question or comment I have. Do we think that language is sufficient to cover that?
Can we pull that back up, or have any other, if anybody else has any thoughts on it?
Mary Kay, do you know what rule that was under?
Is
Is it 7104?
And 105.
The warrants.
Thank you.
So I'd invite anybody else looking at that because Judge Humphrey, I'm not going to be remotely close to an expert to provide my own opinion on how that's going to apply in a courtroom, but if we think that's sufficient or not.
If it would help, I have the definition of juvenile arrestee in front of me. And I'm not sure, is there a way for me to post in the chat so everyone can see it?
Bernice, I believe you can actually share your screen by using the
Okay.
bottom green button.
So here it is. Me has been charged as an adult. Is that now I don't have the proposed rule language we're talking about in front of me.
Denise, I'll read this to you. So 70105, detention and hearings on failure to return. This is the first sentence is existing language. Where circumstances require the holding receiving court to detain any juvenile under the Interstate Compact, the type of secure facility shall be determined by the laws regarding the age of majority in the holding/receiving state. And then this new language says, this would include an out-of-state juvenile that is charged as an adult and is subject to extradition under the Uniform Criminal Extradition Act or the home/demanding state's own extradition laws.
So does this not just go to where the child's going to be held pending extradition? And it goes to the laws of the receiving state?
Right. So I
Which-
would interpret it in Indiana that they would follow this current law right here that you have 368, Bernice.
Yeah.
I agree.
And I suppose in theory, it could be different from state to state. If other states have not adopted statutes that are in compliance with federal law, right?
So Mary Kay, where does that leave us on that proposal? Or Judge Humphrey, does that answer your question?
I think it answers the question.
Okay. So is the the court definition, the only one we have some conversation to have about separately. Are we good with the rest of the package? Okay, if so, then what I'd suggest and what I'd invite is a motion to what Mary Kay recommend or request that you vote yes on all of the rules with the rule proposals with the exception of 1-101, which we're going to discuss separately.
So moved.
Is there a second on that?
Second.
Judge Humphrey? Thank you. Okay, Jenny, go ahead on that. Did you understand the motion, Jenny, that I said and
Yes.
then asked someone else to say for me?
Yep, so we're voting on the package minus the definition of court.
Right. Okay, go ahead.
All right. Justin Faulkner,
Yes.
Mary Kay Hudson,
Yes.
Bernice Corley,
Yes.
JT Parker as proxy for Chris Naylor,
Yes.
Laura Barry,
Yes.
Steve Luce,
Yes.
Judge Humphrey,
Yes.
Jill Gruber as proxy for Rob Carter,
Yes.
and Don Travis as proxy for Terry Stigdon.
Yes.
Okay. Thank you, Jenny.
In
I'm
favor
assuming it's-
unanimously.
Perfect. April, if you could pull up that rule again, then, I guess the issue sitting in front of us is, does this make it more confusing or less? And I have to think the intent was to be the or that Senator Sandlin's talking about, but when they write and, we could certainly get into a hyper-technical issue where it does have to be both. And here in Indiana, we have courts that are only statutorily created that don't have the constitutional foundation. So you might run into a sticking point. So the question is, do we ask Mary Kay to carry this forward with our endorsement or not? And Mary Kay, I suppose one of my thoughts is there another mechanism? I know that they have a general counsel and some advisory opinion process that could clarify for this. If we do say this is the definition, that could clarify what we mean is constitutional, either constitutional or statutory authority.
We could certainly ask for an advisory opinion from Tom Travis. No, theirs is, the juveniles is a different attorney. It's Rick Masters still. My guess would be, though, if we're looking at the strict reading of this versus the intent, where it says and, my sense would be is that the general counsel would say, we should change this in an advisory opinion back to an or. My opinion is that this rule change is probably at the request of a state who had some unique problems. I don't know that we have ever had this problem. April or Ian, correct me if you've seen this come up, but it sounds to me like there may have been a state that for some reason they just were really challenged by the use of the term court, when I think in Indiana, we've never had a problem with a court being interpreted as any sort of a judicial officer. So
To me, that sounds like this rule amendment would potentially create a problem where we have not had one here before. Is that? But I would open it up if, sort of how folks want to vote yay or nay on this. I don't want to, I think I would be personally a no, just not wanting to buy an additional issue that we don't necessarily have. But I invite whoever, other additional discussion or whoever wants to make a motion one way or the other.
It's interesting when you look at the justification for the change, they make it sound like they were only going to remove the word court, and then they put the other stuff in that causes the problem.
Yeah, I mean, clearly the problem is the fact that they're trying to be comprehensive or inclusive in the scope of authority or the way in which the authority is derived, but they actually limited it by doing it that way. My opinion, Justin, I agree with you, is that I would rather leave the rule as it is than vote yes on something that we know to be problematic. So
I agree. I think we're creating a problem for Indiana where it doesn't exist right now, and I will make a motion that will be helpful to that we say no on this rule amendment.
Is there a second on that motion?
Second, this Bernice.
Okay, any other discussion? Any opinions go in the other direction?
I have a quick question. Mary Kay, it's been a while since I've been at one of the annual business meetings. When you vote, do they allow you to explain why you're going to vote no? Like at least put some context behind it.
You vote by like a little button.
Mhm.
So technically no, but the rules committee, of which I'm a member, is going to be doing a presentation. And as luck would have it, I am doing the portion of the presentation on the definition section. So I guess
How fortunate.
I can tell everyone that I'm going to vote no. So, yeah.
Okay.
So we'll be able to talk about that during the presentation. And I will bring that up to the compact staff and the compact rules committee chair in advance, just so that she's aware of it.
Okay, we have a motion and a second. Any other discussion on it before we proceed? And I give it to Jenny. I can't see everybody's faces, but Jenny, go ahead.
Sure. This is to vote no on the amendment to the definition of court. Justin Faulkner,
Yes, I vote no.
Mary Kay Hudson,
Yes.
Bernice Corley,
Yes.
JT Parker,
Yes.
Laura Berry,
Yes.
Steve Luce,
Yes.
Judge Humphrey,
Yes.
Jill Gruber,
Yes.
Don Travis. I'm sorry, Don, I didn't hear you.
Sorry, I was on mute. Yes.
Thanks. That's everybody, Justin.
I didn't. Senator Sandlin, did you vote? Did you?
He's not a voting member.
Oh, look at me. I'm just going through the faces on my Hollywood squares.
Oddly
Sorry.
enough, that's by statute. We can't really figure out why.
Okay. All right. Well, I think that, Mary Kay, that covers the juvenile side, right? Okay, so let's go ahead and go to the adult.
The adult is much more straightforward. And April will pull those up one at a time. The first proposal is actually a proposed change to the bylaws of the Interstate Compact, or the ICAOS ex officio membership list. There is a proposal to add the National District Attorneys Association to the list of ex officio members. Those individuals are routinely invited to participate in any of the meetings, and they do attend the annual business meetings. And the executive director for ICAOS has pretty frequent contact with the National District Attorneys Association and is making this request. The next one is around resident definitions. The definition of a resident is kind of historically very complex and frequently subject to interpretation as new variations present themselves between states who are negotiating transfers based on residency. So this definition kind of expands on what we previously referred to as continuously inhabited estate for at least 1 year prior. I think the rule, or the issue that this is trying to fix, is that continuously inhabited estate for at least 1 year prior does not necessarily mean there's no time frame for that. So in theory, that could have been at any point in time. They had been in a state for 1 year. So that caused some problems. And so this is attempting to fix that. And then the next rule amendment is regarding the probable cause hearing in the receiving state. This adds to section B, just really is more of a clarification that no waiver of a probable cause hearing shall be accepted unless accompanied by an admission of the offender to one or more violations of the conditions of supervision. That would result in the pursuance of a revocation of supervision in the receiving state. So this really is limited to, these are not minor and technical violations. These are violations that in the receiving state, if I'm an Indiana probation officer supervising someone for Illinois, would result in the pursuance of a revocation, meaning the filing of a petition to revoke or violation with the court. So this really is not a significant change in practice. It's just really clarification. And then that language is added also in 4 for the same purpose of clarification. Or excuse me, F, not 4. And then the next package is actually a series of rule amendments surrounding warrant timeframes. There's 6 rules that the Rules Committee is proposing changes to. This has been a conversation that's been happening at the compact level, the commission's level for a number of years. Previously, as you can see in these rules, there are several different timeframes listed for when or under which warrants must be issued, all the way from the rules being silent on a timeframe to upon receipt of notice of a violation, a warrant must be issued, which is essentially immediately, or 10 days or 15 days or 30 days. So it makes it really confusing from a training and implementation standpoint and a tracking standpoint to have all these different warrant timeframes. And so the Rules Committee proposed standardizing the warrant timeframe to 15 business days to obtain a compact compliant warrant, which means that it is a no bond warrant that has it's a national warrant with no bond versus one that is only good for the state of Indiana or is only good regionally. So these warrants have to be entered into the NCIC. The challenge with this rule proposal is that we do have some states who say that it is difficult for them to get compact compliant warrants within this 15-day time frame. It's a 15 business days, which is in effect almost 3 full weeks. However, if we look at the way the rules were originally written, in most cases, the 15 days is actually more days now, if this rule changes, than they currently have under the rule of, say, 10 days or upon receipt. So we, the Rules Committee, and I'm chair of the Rules Committee, think that more often than not, counties or states are able to comply with this time frame. I know in our experience, sometimes when we have challenges with warrants, those tend to be the cases that stick out, that you remember because you have challenges getting them issued for whatever reason. But most of the time, getting a warrant within this time frame is a very reasonable request and is very doable. And then to the extent that we have counties or states that are not able to comply with those timeframes, we as a Interstate Compact are in a position to be able to offer training and technical assistance. So I do expect that vote on the warrant package, moving everything to a 15-day time frame. I'm not entirely sure how that vote's going to go, but I recommend, I think, as well as our compact staff, that both from a consistency standpoint, so that everybody understands what the expectation is and what the time frame is uniform, and the fact that we think that it's very realistic and doable to be able to comply with compact compliant warrants within 15 days. I would recommend that this body vote in favor of that change.
So if I could, Mary Kay, I think you said this, but I want to make sure I'm clear because you're talking about counties and states run into this. We don't have an issue here in Indiana with 15 business days typically as the norm. There may be exceptional cases where that could be an issue, but I did see that most of those are increases from 10 to 15 days. There's a couple where it looks like it used to just say upon whatever you shall, and now there's a 15-day deadline installed, but we don't think that's going to create a problem here.
I really don't. I mean, I think once in a while we have some challenges with warrants. And sometimes it's the fact that they're not no bind, or that they haven't been entered, or that they're not national level warrants. And that's usually just something that we work with the county on an individual basis. Also, sometimes when we have individuals who are not in compliance, so they've moved out of state and they're not in compliance, sometimes courts will seek to terminate their supervision rather than call them back or issue a warrant, which is not permitted under the compact. So sometimes you have to work through some of those issues, but they're outliers. And typically we can resolve that within a pretty reasonable time frame. Our staff is pretty well aware when these warrants aren't being issued, and they tend to watch them. So we can be proactive in getting them, or working with the states if they're having challenges. And sometimes it's a call to the judge or to a prosecutor or even to a sheriff's office.
Okay, thank you. Did you have any other rule proposals for the adult side? Is that the whole package?
That is the entire package.
Okay. Did anybody have any questions or issues or concerns with any of those individual rules as they were presented, or the proposed amendments? Okay, seeing none, then I think we take these as one entire group. If someone is in favor of voting for Mary Kay to vote yes on them, I would entertain a motion on that. Judge Humphrey, thank you. First to unmute.
Sorry, I was on mute.
All right, Don, I'll take that as a second.
Yes.
Go ahead, Jenny.
Okay. This is to vote yes as a packet on the adult rules. Justin Faulkner,
Yes.
Mary Kay Hudson, Mary Kay,
Yes.
and yeah, you're super low. Bernice Corley,
Yes.
JT Parker,
Yes.
Laura Berry,
Yes.
Steve Luce,
Yes.
Judge Humphrey. I'm sorry, Judge Humphrey, I didn't hear you.
Yes.
Yeah, for some reason, some of your audio was really low. Joel Gruber
Yes.
and Don Travis.
Yes.
Thanks, everybody. That one's also unanimous.
Okay. Thank you for your attention and input on those particularly. We're at the, anything else on rule amendments, Mary Kay, that you want to talk about? Okay, we're at the other business portion of our agenda. If anybody on the council has other business, Mary Kay, if you have staff with other business. Okay, great. You see the meeting schedule on the agenda. Again, there's no October meeting. The next one is December 10th. Mary Kay, I assume either at that meeting or after the annual business meeting, we'll get an update from you on the outcome of the rule amendments.
Yes, I'll provide an update.
Okay. All right. Thanks everyone again for your attention this afternoon. We worked our way through that. I think that's important. That's good feedback to go back to them nationally. So that is it. Unless anyone has anything else, I would take a motion to adjourn, and then we shall adjourn. So moved. Judge Humphrey has adjourned us all. Thank you very much, everyone.
Bye.
Thanks.